Ready? Start. The original defendant Mahadev has filed present miscellaneous civil appeal challenging the order dated 10th March 2005 passed below Exhibit 5 in RCS number 1000/2010 passed by CJJD Awath. The parties are called as per their original nomenclature from the suit. The appellant is the original defendant and respondent is the original plaintiff. Para. In short, facts of the application Exhibit 5 are as under. Para. According to plaintiff, that is respondent, herein she is owner and possessor of house property number 1104 at measuring east west 25 feet, south north 25 feet, bounded by four boundaries mentioned in the para number 2 of the application. The above house property is called as suit property hereinafter in the present order. The suit property was having old house number 1119. The plaintiff since 1975 using the suit property. In the year 1975, the plaintiff by constructing Kacha house residing in the suit property. Thereafter, she erected tin shed and residing at the suit property. The husband of plaintiff and other members of her family also residing in the suit property with the plaintiff. In the year 1976, the Gram Panchayat has given house number and recorded the name of plaintiff at Gram Panchayat record. In the year 1997-98, the suit property was having house number 1119. The plaintiff herself deposing the Gram Panchayat tax of the suit property. The defendant is not having any concern with the suit property. Para. On 9th November 2010, plaintiff along with her husband visited Awath, Taluka Awath. The defendant, his son, wife and others by illegally entering in the suit property caused damage to the said tin shed from the suit property. The plaintiff at about 6 p.m. visited at suit property. She got knowledge that defendant, his wife, son and others caused damage to the tin shed from the suit property. Therefore, the plaintiff filed a report against defendant, his wife and son at police station Awath, Taluka Awath. On 10th November 2010, the plaintiff was doing cleaning work at the suit property. The defendant reached there and asked the plaintiff that she should quit from home, otherwise he will compel her from quit from the suit property. Thus, the defendant caused obstruction in the possession of the plaintiff of the suit property. Hence, plaintiff compelled to file present suit and application against the defendant. Para. The defendant is not having any concern in regard ownership and possession of the suit property. The plaintiff is legally owner and possessor of the suit property. Prima facie case and balance of convenience is in favor of plaintiff, and if the defendant continued obstruction in possession of plaintiff, then plaintiff likely to face irreparable loss and she likely deprived from her legal rights. Therefore, the plaintiff has requested that defendant, his relative, servant and anybody on behalf of him may be restrained by way of temporary injunction order from causing obstruction in the possession of the plaintiff over the suit property till the decision of the suit. Para. The defendant, that is appellant, herein filed his written statement, come say, and resisted the application, contending that the suit filed by the plaintiff is bogus, false, and imaginary, and same is not legal. The contents from application exhibit 5 are bogus and false. The said application is not legal. The defendant never resided at Mumbai and he is permanently resident of Avath. The plaintiff permanently residing at Avath, Taluka Avath. The plaintiff has wrongly mentioned house number as 1104. House number 1104 is not in existence. The four boundaries given in the para number 2 of the application are of house number 1902 and not of house number 1104. The plaintiff is neither owner nor possessor of the disputed house property. The house number 1104 was never having old house number 1119. The plaintiff was never in use of the suit property. Since 1975, she was never residing at the suit property. Since after marriage, the plaintiff residing with her husband at Avath, Taluka Avath. The defendant never caused damage by entering in the suit property to the tin shed. The plaintiff has filed false report against defendant at Avath. The cause of action shown for filing the suit is bogus and false. The plaintiff falsely stating that the defendant is not having any concern with the disputed house property. The prima facie case is in favor of the defendant. The plaintiff has failed to prove prima facie case in her favor. The bogus entry in the name of plaintiff in regard to the disputed house property taken in Avath record, the plaintiff is not going to face any loss if temporary injunction is not granted. On the contrary, if the temporary injunction granted, then the defendant is likely to face irreparable loss which cannot be compensated in monetary terms.